Ladies and gentlemen, dear guests, I thank you for this honoring opportunity to be able to present to you the position of the Curia concerning the legal unity activities that are in line with the new criminal code. Hegel defined law with the following words: reasonable will in a external form. And this is especially true for the criminal code defending the rights and interests of society. The Hungary's first code, the Csemegi Code, starts with the following words: we are presenting the bill and we do not think that it requires any justification from the perspective of necessity. And this also applies to the new Criminal Code of Hungary. For both of these acts, it is absolutely applicable to say that the achievements of Western civilization and the rights of humankind should be protected, and it is to be commended what these two pieces of legislation did in the interest of these goals. The crimes are defined in both of these codes, as well as the legal consequences are defined in such a way that give a perfect response to the needs of society, as a result of which it is able to create confidence and to maintain such confidence from the perspective of society. The new Criminal Code of Hungary also took the accelerated scientific development into consideration, as it also considered the new EU requirements. At the same time, it also paid attention to the legal traditions that were worked out in the past 150 years. So it respected Hungarian legal traditions as well as the traditions in the application of the law. In spite of these ambitions and efforts, we can still conclude that the efforts were significant. The goals of the new criminal code must be understood and properly interpreted by the judicial system because, as our judicial expert concluded, it is important to consider not only the letter of the law, but the spirit of the law as well. Mihály Tóth, the professor of Hungarian law, said that it is now the procedural law experts who has the task of enforcing the legislation. So we have to enforce legislation with a view to the new situation and new phenomena in society, in life. And therefore, the judicial system must be able to interpret the will of the legislator, but on the other hand, it must always adjust the adjudication to the current circumstances. Árpád Erdei highlighted that only excessive traditional thinking will superimpose dogmatics over development. We have to stress two things in this context. On the one hand, a well-founded dogmatic aspect is to be commanded, and it is inspiring respect if the judicial system does so. However, the judicial system should not go into extremes in applying new legal institutions. Wherever the text of the law is clear, the judicial system should not interpret it in any other way. On the other hand, interpretation is required and inevitable in every case when a new solution is enacted, something that has not been known to Hungarian practice in the past. As a result, it is vitally important how the courts are acting. We have several instances of emphasizing in legal literature that such practice is always necessary. And even the lowest instances of the court system are obliged to interpret the law because there is no legislation that would be able to anticipate every new phenomenon or every fact or circumstance in life. As a result of this, the legal unifying activity of the Curia continues continues to be necessary. The application of the law cannot be different from region to region. As the Legal Unity Council of the Curia recently formulated, maintaining legal unity is a constitutional requirement, and therefore the law courts must interpret the situations according to the same principles. It is impossible to accept a divergent legal practice, because that would be a violation of the Constitution. So the unity of criminal adjudication means that the same norm are interpreted in the same way by the various court resolutions. Criminal legal unity is a goal that we have to strive to achieve, but its full accomplishment is excessively difficult, because when working towards legal unity, we have to maintain a very sensitive balance, whereby we do not violate the independence of the courts, but on the other hand, such interpreting activity should not be equivalent to legislation, because if that happens, it will have detrimental consequences very nicely laid out by the previous presentation. So we do not enact new legislation. We just continue to interpret the existing ones. However, we must respect the old principles in this respect. Any new notion in the criminal code must be interpreted according to the spirit of the criminal code. What does it mean? Dogmatics can be a good basis, and we have to walk the bumpy road of legal interpreting in a solid manner. There are historical traditions for this behavior, and I would like to illustrate this statement by various resolutions adopted by the Curia in 1928 and 1927, because these resolutions clearly indicate that today's legal interpreting practice is fully in line with Hungary's historical legal traditions. The first resolution from 1928 regarded the temporal scope of the code, and it concluded that from the various legislation, we have to use the one that is most beneficial to the indicted party, and only one piece of legislation can be applied. A legitimate legal defense was always a very important notion. In the case of a simultaneous attack, when every party is an attacker and every attack is illegitimate, we have to adjudicate the case most strictly. Mitigating circumstances must be taken into consideration, but only if justified, and we have the same attitude today. And when it comes to fraud, the Curia also adjudicated properly, and in the last case, which took place in 1928, the case concerned the fraud and the falsification of private documents, and the resolution concluded that it is necessary to investigate every single fact and details of the case. So such situations are interpreted in the same way even today. Today, one of the most important constitutional obligations of the Curia is to ensure legal unity, and it means that by interpreting legislation, we have to support a unified application of the law. The Curia is the center of this activity, and this is an exclusive responsibility that must always be remembered by the Curia, said Varga Zsolt, professor who is the president of the Curia. And the Legal Unity Council also stressed that this obligation is performed if the principal content of the legal unity resolutions can be discerned in similar cases in an integrated manner. However, the guidance of the Curia are not sources of legislation. They do not create new pieces of legislation. They only explain and interpret existing legislation, and these resolutions only wishes to lift to the surface the proper interpreting of the existing law. Therefore, the judicial independence will have to props, mainstays, judges can never change legislation. It means that the judicial system will perform its activities in an independent manner, and at the time when the legal issue is raised for the first time. Later, however, interpreting is more restricted, and the law courts are restricted by their own earlier decisions and resolutions. Otherwise, they will fall into the trap of acting in an arbitrary manner. The Curia is faced with serious challenges in the course of such activities. It is, however, trying to rise to these challenges, and for the lower courts, it is providing the right guidance and instructions. We can, however, say that from time to time, it might be easier to discern the prophecies of the Delphi Center of Prophecies in ancient times than it is today to understand some of the law provisions today. New notions also surface which never had any antecedents in the Hungarian legislative system. For example, relationship violence is such a new notion. Under these circumstances, it is a real challenge to properly interpret the legislation, and there is a lot of difficulty in these cases when we want to issue proper guidance. Mihai, taught professor, humorously pointed to the fact that rather complicated interpretations are published under these circumstances that are very difficult to understand. The Royal Curia has hundreds of years of tradition in this, and we can conclude that the current Curia is also rising to the challenge. Let me focus on a very special difficulty in which the Curia has been cornered, so to say. It is certain resolutions of the human rights courts of Europe that we find ourselves cornered. We have changed the legislation, and we have introduced the mandatory clemency procedure in actual life imprisonment after 40 years. The European Court, however, requires the Curia to conclude that after 25 years, people in life imprisonment can be released on parole. And such a mandate is not accorded to the Curia in any country. This is a requirement that should be imposed on the legislator. And the Curia concluded this for 150 years. The Csák Code has followed the principle that courts cannot resolve debates of public law. It can only defend existing law but cannot enact new legislation. So, with the words of Finkei, with the inflammatory words of conviction, we have to interpret the law, but we will not be the champions of extreme movements when it comes to interpreting legislation. The same professor concluded that when a court adopts a resolution, it has to be the most fair and most just from a humane perspective. The limited precedent system is also applied, and the legal unity is a goal, and these two can be seen as the most important instruments of our ambition to achieve legal unity. And without a full list, I would like to refer to a couple of such resolutions that had indeed a major impact. A few of them were based on previous dogmatics, adjusting the legislation, the interpreting to the new circumstances, but also there are some that help the application of absolutely new pieces of legislation. Most recently, a legal unity resolution was adopted whereby principle or guidance 15 was replaced. It interprets the most important crimes in the interest of defending life. For example, assault resulting in death or attempt to commit homicide, and it also deals with the qualified cases of manslaughter. And we are talking about cases which provide, or we are talking about interpreting that are not only applied in the court system but also taught at law schools. I think I can dare to say that the Constitutional Court will never annul this legal unity decision, as the Constitutional Court president was one of the persons who signed this resolution in her capacity as a member of the Curia earlier. In view of the changed legislative environment, we heard that legitimate self-defense became in focus, and the Curia decided to issue an instruction concerning this, especially with regard to the legitimate situational self-defense. In 2015, the Curia responded to the resolution issued by the European Court of Human Rights, in which the resolution said that in the case of actual life imprisonment, the resolution can be adopted in line with international treaties. If there is no such treaty, the Hungarian court cannot adopt a resolution that is a violation of the legislation, meaning that it cannot adopt legislation itself. So whenever new legislation is required, the legislator has to lead the process, because a missing legislation cannot be adopted by the Curia. This is an extraordinary issue that we are struggling with today, and we believe that new legislation must be adopted to resolve this situation. It was in 2019 that the Curia understood that a question was not governed in a uniform manner, namely, if a CEO can commit fraud at the expense of the company that it is at the helm of. And the Curia concluded that such fraud can be committed. So adjudication was made uniform and integrated in this particular question, namely, it concluded that a contribution to the assets of the company is separated from the private wealth of these individuals. We can see that the Curia is issuing guidance with regard to the most challenging parts of the Criminal Code. We are playing a double role, a dual role. On the one hand, we have to preserve the values rooted in our dogmatic historical development, but on the other hand, we have to adjust ourselves to the changing legal environment. In the past 10 to 12 years, the pace of amendments has not changed, in spite of the fact that it was a goal of the legislator to create an integrated system. So the Curia must stand prepared in every case when new legal institutions are introduced and they need interpreting. The reasons given for the new act clearly indicate that the Criminal Code is playing a closing role in the legal system, and the Curia must always stand ready to provide interpreting. We would like to say that as the rays of the sun dry up the drops of rain and rejuvenate the earth and replace darkness with light in a similar manner, the activities of the Curia provide light on every cobblestone of the path towards a legal unity in Hungary. In the course of these activities, we must also consider the need to meet international requirements, but at the same time, we must uphold our traditions. As Professor Finke said, if we have to deal with our problems, we do not need to adopt the various new resolutions as if they would be able to work miracles. If we study the new legal institutions on the spot in the countries where they were invented, well, let us study them there, but let us return to Hungary and act according to the spirit of the Hungarian society in line with the needs of Hungarian society. We have no reason to be ashamed for the system that we have. And Mihai Tóth professor said that legislation is not a brainstorming exercise and criminal code is not a laboratory for experiments. Of course, the judicial system does not always perfectly apply the will of the legislator, but we can certainly conclude that there is a serious effort made towards this goal. In summary, we can say that the Curia is issuing guidance that support and help the judicial system to enforce the goal of the criminal code, and the reasons given in the Csák code are excellent in this respect. When something is prohibited by the state and criminalizes the activity, or when it allows any activity to be performed, it acts in the interest of exercising its moral responsibility. And it rejects immorality and upholds morality for the goal of protecting the interests of society. Thank you very much.